What if I told you that in just a matter of weeks, two major court decisions may have changed what counts as legal carry, where you can walk with a firearm, and even how federal law treats some gun owners who use marijuana? What if the rule you thought applied at a gas station, a grocery store, a restaurant, or a parking lot is no longer the same rule today? And what if thousands of gun owners are still following the old understanding because they haven't heard what the courts just did? If you own a firearm, carry regularly, or simply want to stay out of legal trouble, you need to hear this because the landscape just shifted again. Before we get into it, if you want plain English updates on major legal changes that affect everyday Americans, hit subscribe, drop a comment with your state, and stay to the end because some of these changes expand rights, but others come with serious warnings that people are already misunderstanding. So let's clear something up right away. The title says 7 gun laws just changed after the July 2026 court ruling, but the most important reality is that the biggest rulings actually came down in June 2026 and are now reshaping what gun owners need to understand in July 2026. That matters because this is not just one headline or one court soundbite. This is a real legal shift happening right now, and if you're still relying on last year's advice, you could be badly behind. Source. The first huge change is this. The Supreme Court struck down Hawaii's rule that treated private property open to the public as a default no-carry zone unless the owner gave express permission. Think about what that means in normal life. If you pull into a gas station, stop by a store, walk into a restaurant, or enter some other business open to the public, the state cannot simply assume you are breaking the law unless the owner has posted some kind of yes, you may carry approval. The court said that flips the normal rule and puts too heavy a burden on the right to bear arms for self-defense in daily life. So ask yourself, how many owners have been living as if every open business was legally hostile territory unless told otherwise? That's one of the biggest changes right there. Source. The second change follows directly from that. Property owners still have rights, but now the burden shifts back to them if they want to exclude firearms from private property that is open to the public. In plain English, the ruling means the default is no longer guns are banned unless invited. Instead, in the places affected by these laws, it goes back toward the more traditional rule. If the business owner wants to forbid firearms, the owner has to say so. Why does that matter? Because in the real world, most businesses are not posting guns welcome signs, and under the Hawaii-style rule, that silence could effectively criminalize ordinary carry. The court rejected that framework. Source. The third change is bigger than Hawaii. This case doesn't just matter on one island or in one courthouse. According to NPR and SCOTUS blog, similar laws existed in other states, including California, Maryland, New York, and New Jersey. So when people ask, is this just a Hawaii story? The answer is no. This is one of those rulings that sends a message far beyond the state named in the case. If your state tried to make concealed carry practically impossible by treating huge parts of everyday life as off-limits by default, that strategy just took a major hit. And isn't that the real question every owner should be asking right now? Not just what happened in Hawaii, but whether my state uses the same playbook. Source. Now here's the fourth change, and this is where people need to be careful. A lot of viewers are going to hear this ruling and assume it wiped out every sensitive place restriction. It did not. The background of the case involved laws restricting carry in places like bars, restaurants serving alcohol, parks, beaches, and other designated locations. But the Supreme Court's core holding focused on the default rule for private property open to the public. That means this is not a magic sentence that suddenly makes every sensitive place law disappear. Some restrictions were part of the background, some may still be litigated, and some state-specific limits may still stand. So the smart question is not, did I just win everything? The smart question is, which rule was struck down and which rules are still waiting for the next lawsuit? Source. The fifth major change comes from the other huge case, United States versus Hemini, and this one could shock a lot of people. The Supreme Court unanimously ruled that the federal government could not automatically strip a man of his Second Amendment rights simply because he used marijuana regularly. Let that sink in. The government's theory was basically that if you use marijuana a few times a week, that alone can make you a prohibited person under federal law. The court said no, not on those facts, not under that historical test, and not without something more. So now the question becomes, does ordinary recurring marijuana use by itself automatically erase your right to possess a firearm? After Hamani, the court said that answer is not so simple anymore. Source. But don't make the mistake of thinking Hamani created a free-for-all, because that brings us to the sixth change. The ruling was narrow, very narrow. The court did not say every drug user can own guns under every circumstance. It did not wipe out all drug and gun restrictions. And it did not say intoxicated carrying, addiction, dangerous conduct, or evidence of real impairment can't still be punished or restricted. In fact, the opinion and the follow-up legal analysis make clear that the government may still have room to regulate people who are actually dangerous, presently intoxicated, addicted, or involved with more serious substances. So if someone tells you this ruling means weed users can do whatever they want now, that person is overselling it, and overselling it in this area can get somebody arrested fast. Source. And that leads straight into change number 7, which may be the most important of all. From this point forward, a lot of gun cases are going to turn on the details. Not slogans, not memes, not activist sound bites. The details. What drug was involved? How often was it used? Was there proof of dangerousness? Was the person carrying while impaired? Was the location a public business, a posted private property, or a state-designated sensitive place? Was the law a blanket ban, or was it tied to specific conduct? This is the new reality. The court is increasingly forcing governments to justify restrictions with history and analogy, but that also means future cases may rise or fall based on the exact record in front of the court. So if you're a gun owner, the days of one-size-fits-all legal advice are getting more dangerous, not less. Source. Now let's bring this down to street level. What should the average owner actually do after these rulings? First, stop assuming the old default rules are still accurate. If your state had one of these private property open to the public restrictions, you need to check whether enforcement changed, whether injunctions apply, and whether your local courts are updating their guidance. Second, do not assume that one court victory means every carry location is safe. If a business posts no firearms signs, that still matters. If your state has alcohol-related carry restrictions, those may still matter. If you carry into a place that remains classified as sensitive under your state's laws, you could still be walking into a case. The real question is this: are you carrying based on law or based on internet confidence? Because those are not the same thing. Source. And for viewers asking about marijuana and firearms, slow down before you celebrate. Hamani is a major ruling, but it is not blanket immunity. Federal law, state law, licensing rules, charging decisions, and the facts of your case can still collide in ways that create real risk. Some states may react differently. Some courts may read the decision narrowly. Future prosecutions may focus on impairment, addiction, or other substances. So yes, this case could become a huge turning point, but no, it is not a permission slip to ignore every other legal warning. If anything, the biggest lesson is that gun owners now need more precise legal awareness than ever before. Source. Here's the bottom line. The legal map just changed in at least 7 important ways. The court pushed back on laws that made everyday carry nearly impossible in ordinary public-facing businesses. It restored a more favorable default for carry on private property open to the public in places affected by these laws. It signaled trouble for similar restrictions in multiple states. It reminded everyone that not every so-called sensitive place is automatically resolved by this case. It narrowed the federal government's ability to prosecute at least some marijuana users for gun possession based on use alone. It left room for restrictions tied to danger, intoxication, addiction, or stronger evidence. And it made clear that future gun cases are going to depend heavily on facts, history, and the exact wording of the law at issue. Source. So let me ask you, do you think these rulings restored constitutional rights, or do you think they made the law even more confusing for ordinary citizens trying to stay legal? And what state are you in right now? Because your location may determine how much these decisions change your day-to-day reality. Drop your state in the comments. Tell me whether you want a follow-up video on how this affects concealed carry signs and sensitive places. And if you found this useful, subscribe and share this with another gun owner who may still be operating under the old rules. Because in 2026, not knowing the change can be just as dangerous as breaking it.